today is, I think, one of the darkest days in our country's history in terms of parliament. I think somebody can only liken it to sometimes in 1982 when they passed what was called in the Section 2A of our Constitution, which made the country a single-party dictatorship. It was passed in the same manner and fashion as it was done today in Parliament.
Okay.
In other words, that was the time when we were trying to form another political party.
Okay. So let me get this clear. You're saying it's not that there will not be elections, it is the opposition that will boycott elections.
It's not a question of boycotting.
You're saying there will not be elections.
We are saying there will be no elections which are going to be rigged. We will not allow it to happen.
Okay.
In other words, they are attempting to do it, but we will stop them from doing it.
So you're saying they are attempting to rig the elections already?
Yes.
So I'm asking you that question again. Are you saying there won't be elections? Or you'll not participate?
There won't be elections which will be rigged. This is what we're saying.
Okay.
So we are going to take the steps to ensure that the next coming general elections are going to be fair, free, open, transparent, and verifiable.
Okay. How do these amendments amount to rigging, in your view?
Because, you see, in the past what has happened is that the people who are what you call ghost voters have been allowed to vote, to participate in the voting. How do they do this? Particularly in their strongholds, they first have registered even the dead people. The names have not been removed from the register, and even underage children. And when the polling day comes, the first thing they do is they remove any agent from the opposition. Our agents, like last time, were beaten up and then thrown out of the polling station. So when the polling ends, then they now cross all the other names, those people who have not turned up to vote.
Okay.
And that's why you have, for example, 95 up to 100% and 102 voter turnout in those areas.
So that's what you're saying. That is what you're afraid of. That is what you think may happen.
Yes, that is what these changes are actually meant to stop.
Okay, I'll come to that. We'll come and discuss. I mean, all the problems of manual or electronic. First, you went today in court. The judge was very clear when giving directions that he will handle the matter, Justice Odunga, and if he finds that the outcome is, I mean, the laws in Parliament were unconstitutional, he will not hesitate. He will not hesitate to change them or take action or to strike them down, just like the security laws a while back. So why couldn't you wait for the decision of the judge and immediately call for mass action?
No, you see...
Because you did that because you believe in the rule of law, isn't it?
Yes, certainly.
So why don't you wait for the rule of law to take its course?
No, that is a parallel process, and that is going on. What we're talking about right now is that we've seen that Jubilee is basically trying to abuse their numbers in Parliament to impose a law on the people of Kenya.
Okay.
And that is what we are trying to prevent.
But you cannot say it's a parallel process because you're going to the streets because of what happened in Parliament.
Yes.
You went to court because of what happened in Parliament. Yes. The court is yet to give a ruling on that. Yes. So why would you go to the streets?
But there's still a lot of time. You see,
and the court has guaranteed that it will not hesitate to strike it down if it finds it illegal.
Right. Certainly.
So these are not two parallel.
And where we are standing, we still have a lot of time before the fourth comes. Okay. So if the court then rules that, I mean, the court rules one way or the other, we will not go to the streets. Okay. We will respect the rule of law.
If it rules one way or the other,
yes,
or if it rules in your favor?
Well, no, it's either way the court rules.
So you're going to give it the benefit of the doubt?
Yes.
But now you're not doing it if you're going to the streets.
No. We will.
You're not giving it the benefit of the doubt. If you're saying you're going to give it the benefit of the doubt, you would have at least waited to see how it would go before you make the decision whether to go on the streets or not?
These are parallel processes. We have got the legal process going on, and we have also got political process that is ongoing. And we will not basically sit and wait to see the right of the people of Kenya being trampled on. And that's the reason why we said, well, we have gone to court, and the court has said that they will not hesitate.
Yes.
But at the same time, you see, we have said that we will ourselves call the people to action. Should Jubilee begin to ignore even the court rulings and proceed and procedurally to change the law. Okay. As it is right now, there's still another stage. Go to the Senate, and then from the Senate, then presidential assent. That is when now the other ones will now take place.
So there's still a long process to come.
Exactly.
Then why did you go to the court?
Because of that, we were trying to stop
the
yes.
Exactly, like you said.
And then it became a fait accompli.
Okay, because we want to move away from this now, let me just get this straight. You went to the court because it's a legal process. You want to know whether what was did in Parliament today was legal or illegal, isn't it?
Yes.
You are calling people on the streets because what was done was illegal or legal?
We are calling the people on the streets because the Jubilee's intention is to try to rig the next general elections.
In your view, it was illegal?
It is very legal.
But you went to court to wait so that you find out whether it's legal or illegal.
Hussein, this law was a product of mutual negotiation. You remember we were in the streets. People died. People died because as a result of that. And then there were interventions. The church, the religious community, the members of the diplomatic community, the business community mediated. And we ended up with a select committee, a joint select committee, which then went and negotiated and came up with this amendment to the law. Then there was an agreement between us and the Jubilee leadership that this amendment should be passed without any changes in Parliament. And we gave instruction to our members not to even change a comma or a full stop. That was done. Parliament did pass it. Under the parliamentary law, under the standing orders, a law which has been passed cannot come back for amendment within the next 6 months. 6 months have not elapsed from the time that this law came into effect.
Okay.
So what Jubilee was doing was very illegal. And they have blackmailed the Speaker to try to introduce these changes.
Okay, fair enough. And
remember that Parliament adjourned the day before yesterday at 10 p.m. and the Speaker himself ruled that the next session will start on the 24th of January.
Okay.
That night, the same Speaker was called by the President and told that if he does not reconvene Parliament, he was going to be sacked.
Okay.
And at midnight, he was publishing again another gazette notice convening Parliament. So that session that took place today was itself illegal.
That's why you went to the court?
Yes.
Right. That is why you went to the court. That's what you're saying. You say that the Speaker says everything he did was above board. JLEC says everything they did was above board, and they passed the laws today. You've talked about this law being negotiated. I mean, it was negotiated. We all know. Yes. God and Jubilee sat for almost 30 days to come up with these laws. There was no rider after finalizing everything. There was no rider after the negotiating team of finished their work that any other matter coming up from this must be subjected to negotiations. No, there was no such rider. That's for a fact, isn't it?
No, you didn't need to have a rider.
Why not?
I mean, that is taken for granted. That if it is something that is mutually agreed, negotiated, and agreed upon,
yes.
If one party wants to change it, then there must be a consensus. They must consult the other party. You cannot then unilaterally sit down and begin and say, I'm going to change it, although we negotiated it mutually among ourselves.
First, they say this came from the IEBC, not them, and the IEBC have said so as well. You have been in politics for so long. Over the last 4 or 3.5 years, you've talked about a lot against the Jubilee government and even IEBC, and talked about mistrust. Some would actually argue, how naive would court have been to finish these negotiations and don't have a rider that now mandates any other change to be subjected to consensus?
You see,
if you have been so, you don't really trust them.
Hussein, there is no naivety in this. This is common sense. If there was something that was mutually negotiated, it goes without question that one party then cannot go and change that arrangement. You're saying that the IBC has said as much. IBC must consult both parties. How does it come about that it's only Jubilee that is privy?
Taylor says he's consulted them as a Justice and Legal Affairs Committee.
But we have members in the Justice and Legal Affairs Committee. We have our members there say they have not been consulted.
Okay.
So when the chairman was confronted in Parliament, he was unable to produce even a report of the Justice and Legal Committee of Parliament,
which he said he did today, and that is why they pushed this amendment.
He did not, to our knowledge, because our members have confirmed that no such document was available to them.
So that will be a back and forth. I'll leave it at that. But like I said, Honorable Chief Conga said he did, and that is why he pushed the laws at the end of the day. So in hindsight, you don't think it was a mistake not to make sure anything else that will be changed should be done? I mean, there must have been a rider so that anything else should have been changed must have been subject to negotiations. I mean, in hindsight, you don't think that would have been necessary?
It was not necessary. It is inherent in that agreement.
But it's not.
That it is inherent in that agreement that it should not be changed. That's why the draft bill was supposed to be passed by Parliament without any amendments, since it has been negotiated and agreed upon.
And that it did.
And that's why the President whipped his side, and I also whipped our side.
Good. And it did, and it passed without any amendment.
Passed an amendment, and then you need to know that it can, under the standing orders, it cannot come back until after 6 months.
The Speaker argues differently, Honorable Odinga. But my question to you is, you say, I mean, there was an agreement and there were no amendments at the end of the day, and it should have been passed the way it should have been passed, and then at the end of the day, that is what happens. You're saying this should have been inherent. Generally goodwill from both parties, isn't it?
Yes. Not only that. This was a I'm saying it's a negotiated agreement.
Agreement, yes. But to do anything else, for it to be like it's a must to be subjected to negotiations, depended on goodwill. Because you're saying it should have been inherent, isn't it? It's not the law.
It's not dependent on goodwill.
But it's not dependent on the law.
Yeah, but the law itself says you cannot bring it back. Because saying I've been a member of Parliament for 20 years. I understand the standing orders. And the standing orders say that a bill or that has been passed by Parliament cannot come back for amendment within the next 6 months.
Fine.
The 6 months have not lapsed. That itself was illegal parliamentary.